exercise of power after a proclamation under Article 356 is issued. These substantive challenges which form the fulcrum of the case of the petitioners have been considered. Next issue, whether there are limitations on the exercise of power by the President or Parliament under Article 356. We have held that there are limitations on the power which can be exercised by the Union Government in the state when a proclamation under Article 356 is in operation.
జమ్మూ కాశ్మీర్ కు ప్రత్యేక ప్రతిపత్తి కల్పించిన ఆర్టికల్ 370ని కేంద్ర ప్రభుత్వం రద్దు చేయటం రాజ్యాంగబద్ధమైన అన్నదానిపై సుప్రీంకోర్టు నేడు తీర్పును వెలువరించనుంది. దీనిపై విచారణ ప్రారంభమైంది. ప్రధాన న్యాయమూర్తి చంద్రచూడ్ నేతృత్వంలో జస్టిస్ సంజయ్ కిషన్ కౌల్, సంజీవ్ ఖన్నా, బిఆర్ గవాయ్, సూర్యకాంత్తో కూడిన 5 సభ్యుల ధర్మాసనం ఇవ్వనున్న తీర్పుపై సర్వత్రా ఆసక్తి నెలకొంది.
Haven't applied the standard of whether the exercise of power was mala fide or palpably irrational. Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons.
ఆర్టికల్ 370 రద్దును వ్యతిరేకిస్తూ పలువురు దాఖలు చేసిన పిటిషన్లపై సుప్రీంకోర్టు ఆగస్టు 2వ తేదీన విచారణను ప్రారంభించింది. 16 రోజుల పాటు విచారణ జరిపిన ధర్మాసనం సెప్టెంబర్ 5వ తేదీన తన తీర్పును రిజర్వులో పెడుతున్నట్లు ప్రకటించింది. విచారణ సందర్భంగా కేంద్రంతో పాటు ఆర్టికల్ 370 రద్దు అనుకూల పక్షాల తరపున, వ్యతిరేక పక్షాల తరపున పలువురు సీనియర్ న్యాయవాదులు వాదనలు వినిపించారు.
By a proclamation, assume or declare the powers stipulated in clauses A, B and C of Article 356(1). The powers stipulated in clauses A, B and C of Article 356(1) are not automatically invoked when a proclamation is issued under Article 356. Third, Article 356(1)(a) does not opt for an all or none formula. The phrase all or any does not indicate that the Union Government can exercise a part of the functions of the state government and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the Union Government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the
జమ్మూ కాశ్మీర్ ను 2 కేంద్ర పాలిత ప్రాంతాలుగా విభజించిన జమ్మూ కాశ్మీర్ పునర్వ్యవస్థీకరణ చట్టాన్ని కూడా పలువురు పిటిషనర్లు వ్యతిరేకించారు. కాగా సుప్రీంకోర్టు తీర్పు వెలువడనున్న నేపథ్యంలో ఎటువంటి అవాంఛనీయ సంఘటనలు జరగకుండా జమ్మూ కాశ్మీర్లో భద్రతను కట్టుదిట్టం చేశారు.
Taken by the Union Government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by the Union Executive on behalf of the state is not subject to challenge. Opening up challenge to every decision would lead to chaos and uncertainty. It would in effect put the administration in the state at a standstill. Therefore, the following standard is laid down to assess actions under Article 356 after the proclamation has been issued. A. The exercise of power by the President under Article 356 must have a reasonable nexus to the object of the proclamation. B. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. After a prima facie case is made, the onus shifts to the Union to justify that the exercise of power had a reasonable nexus with the object of the proclamation. And C. The exercise of power by the President for everyday administration of the state is not ordinarily subject to judicial review. The argument of the petitioners that the union government cannot take actions which have irreversible consequences when a proclamation under Article 356 is in force is not accepted. The power of the legislature of the state under Article 357 to repeal or alter or amend a law enacted by Parliament in exercise of the power of the legislature of the state must be read in the context of the amendment introduced by the Constitution, 42nd Amendment Act 1976. Before the amendment, the law to the extent of incompetency would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would in such case make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356 because an ordinance which has the effect of a law by its very nature has a limited life. The argument of the petitioners that Parliament can only assume the lawmaking powers of the legislature of the state when the proclamation under Article 356 is issued is not accepted. The purpose of Article 357 is to ensure that while exercising the powers of the legislature of the state, pursuant to a declaration under Article 356(1), Parliament, or as the case may be, the President, are not impeded by an absence of competence, which would have impeded the exercise of a similar power in the absence of a proclamation under Article 356. Further, Article 357 does not contain a non-obstante provision which overrides Article 356. To interpret Article 357(1) as a restriction on Article 356(1)(b) would be to read in a restriction which the plain terms of the Constitution do not provide. As held above, the exercise of power after a proclamation under Article 356 is issued is subject to judicial review, and immunity from judicial scrutiny does not attach to the exercise of constitutional powers of the legislature of the state. The court, while judicially reviewing the exercise of power, can determine if the exercise of the constitutional power of the legislature of the state by Parliament has a reasonable nexus with the object sought to be achieved by the proclamation. The next issue is whether Jammu and Kashmir retained an element of sovereignty or internal sovereignty when it joined the Union of India. We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state, which were inconsistent with it, but also abrogate them, achieves what would have been attained